Welcome to New Careers Academy, your trusted source for daily current affairs and defense exam preparation since 1967.
जय हिंद एवरीवन, मैं हरताज आपके सामने एक क्वेश्चन लेके आया. The 2017 UPSC trap question. The question which came in the UPSC Civil Services Prelim 2017. Right to vote and to be elected in India is a fundamental right, natural right, constitutional right, or a legal right. What would you choose? And if you picked C, that is a constitutional right, congratulations. You are absolutely correct. That was the answer officially provided by the UPSC in its answer key. But wait, here's a twist. The government of India in 2025 told the Supreme Court that the right to vote is merely a statutory right under the Representation of the People Act 1951. Not fundamental, not even constitutional. So who's right, UPSC or the government? Let's break it down. The right to vote is enabled by Article 325 and Article 326 of the Indian Constitution. So technically, it is a constitutional right. But the actual mechanism, like who can vote, who casts the vote, or who will vote, cast the vote, comes under the Section 62 of the Representation of the People Act, which makes it a statutory right implementation. So while UPSC is correct in theory, the centre's legal position shows a narrower interpretation, making this more than just a quiz question. Now, let's understand how this distinction affects your vote. The legal status of voting in India, to begin with, that is the Representation of the People Act 1951, specifically Section 62, grants the right to vote to every person who is registered as an elector. This is what the government refers to when it calls the right to vote a statutory right, because it is a right guaranteed through a law made by the parliament, not directly by the constitution. Now contrast this with Article 325 and 326 of the constitution. These articles prohibit discrimination in voting on the grounds of religion, race, caste, or sex, and establish that elections to the Lok Sabha and the Assembly shall be based on universal adult suffrage. These provisions provide a constitutional framework, which is why the right to vote is often described as a constitutional right, though not a fundamental one. Here's where the nuances lies. If Parliament amends the Representation of People Act to restrict voting for certain categories like people who are under preventive detention, or with criminal conviction, it can legally do so, because voting is not protected as a fundamental right in Part 3 of the Constitution. Even in multiple rulings of the Supreme Court has generally given the same view. In the landmark PUCL versus the Union of India case, which was in 2003, the court clarified that casting a vote is an act of individual expression protected under the Article 19(1)(a). But the right to vote itself is not governed by the statute. Hence, to put it short, right to vote is statutory, whereas freedom of voting, that is your choice, is fundamental. The legal separation is essential in today's, what we say, democratic disclosure. It determines what can be challenged in court and what Parliament alone can change, directly impacting every voter's power. I hope knowing this helps us protect the rights we sometimes take for granted.
Now, let's talk about the Supreme Court and the centre's latest stand, which is in news right now in 2025. In 2025, especially during the Bihar Assembly elections, a major constitutional question landed before the Supreme Court. Someone filed a petition challenging the practice of uncontested elections. कि कोई खड़ा ही नहीं चुनाव में, एक आदमी खड़ा और कोई वो जीत गया. According to Section 53(2) of the Representation of the People Act, if the number of candidates equals the number of available seats, the returning officer can declare them elected. No polling is required. The petitioner argued this violates voters' freedom of expression under Article 19(1)(a), because they lose the chance to express dissent using NOTA, Now, majority will say, what is NOTA? None of the above. Hence, in short, when there is no vote, there is no opportunity to say I reject all. In response, the center filed an affidavit that drew a sharp legal distinction. Center said the right to vote is a statutory right created by the law, that is the legislation, and the freedom of voting, a species of the fundamental right to free expression under Article 19(1)(a). This distinction was supported by the 2003 PUCL judgment, which clarified that the act of casting a vote is protected as an expression of opinion. But the entitlement to vote comes from ordinary law, not from the constitution itself. Now, here's where it gets technical. The center argued that the freedom of voting exists only when a poll is conducted. In case if it is an uncontested election, since no vote takes place, voters aren't denied a chance to express because no such opportunity arises in the first place. Furthermore, the government emphasized that NOTA is not a candidate as defined under election law and cannot be triggered polling by itself. The Election Commission supported this, stating that treating NOTA as a candidate would require legal amendments. This case pushes us to ask, if citizens are denied even the chance to cast a negative vote, how complete is our democracy? The answer may shape the future of electoral reforms in India and redefine voter empowerment.
Now let's talk about NOTA, uncontested elections, and why it matters. What is NOTA? As I've said earlier, none of the above. The option introduced to empower voters to reject all candidates. मेरे को कोई candidate पसंद नहीं आता तो I can press NOTA. Well, it sounds powerful, right? But here there's a catch to it. NOTA has no legal consequence. Even if NOTA gets the most votes, the candidate with the next highest valid votes wins. NOTA can't cancel or trigger a re-election. And in uncontested elections, voters don't even get a chance to select it because no poll is held at all. That's what this Supreme Court case is really about. The center said NOTA is not a candidate, and under current law, only actual candidates can trigger polling. The Election Commission agreed, saying any change to elevate NOTA to candidate level status would require as an act of parliament to amend the law. In the past 70 plus years of our democracy, India has seen only 9 uncontested elections, most of them decades ago. But the principle still remains the same. Because at the heart of democracy is choice, including the choice to reject. So this debate isn't just academic. It is about how complete your vote really is. Can you truly express dissent if you're denied the platform to do so? That's why understanding this legal framework is crucial for voters and for the democracy itself. Now the question comes, why this debate matters? Why does all of this matter? Because voting isn't just about picking a winner. It's about having the power to express, to choose, and even to reject. And when that power is limited by legal definitions or outdated rules, it directly affects how representative our democracy truly is. The difference between a statutory right and a fundamental right isn't just a legal technicality. It defines how easily your rights can be expanded, restricted, or even taken away, sometimes without any public debate. By calling the freedom of voting a fundamental right, but the act of voting a statutory one, the law creates a gray zone. That impacts every voter, especially in case of unopposed elections or the push to make NOTA more meaningful. And this debate isn't going anywhere. As voter awareness grows and elections evolve, the question of what the right to vote really means will keep returning. So, the next time you head to the ballot box or hear about reforms, remember, it is just not about the candidate. It's about your space to say Yes, no, or neither. If you found this helpful, like the video, subscribe the channel so that we can provide you more insight related to the topics which will help you score well in your examinations. Jai Hind everyone.